We should be recording now.
Okay, we're starting to record. Thanks, Dan. You asked me, I think, the question, Evelyn, about the format. What I intend to do is send an email after toward the last class. So I'm not going to surprise you. I'll tell you what the format is, so you have an idea of that.
Okay, great. Thanks.
Sure. Any specific questions that anybody's interested in? I know one of you sent me Ramos versus Louisiana, or information on that case, which just came out this week by the U.S. Supreme Court. And I sent an email on it. Pretty interesting case. As I said, I really haven't had a chance to fully digest it, but I kind of ran through it.
Very interesting case. Definitely.
Yeah, very interesting.
Louisiana 10-2 conviction for murder. Crazy, huh?
I know, huh? And they got rid of that, but now and I think Oregon was the only state that actually still had that, the ability to split like that. So now it comes down to, where's it sort of going from here? I mean, the con law scholars, like my friend Peter Malaguti would say, you can see the stare decisis issues that are going to come up in upcoming cases. That particular issue is gone, but it was kind of funny how they, at least at my quick look, how they fractured on that point, how to deal with it. So what do you got? Any questions, guys, out there? Specific questions about material? Anything at all? What snacks do you have?
Can you see me?
Who are you?
Jade.
Jade, I don't see you. No, but I can hear you.
Oh, okay.
Oh, I think you might have your camera blocked.
Yeah, I've been working, like, I don't know why it's not picking up.
Yeah, I mean, if you're asking me, you're asking certainly the wrong person.
Can you talk about standing again?
Yeah, sure. Standing, I'll kind of give you the idea. Standing was always thought to be a concept in the Fourth Amendment. And it goes back to the idea that constitutional rights are personal rights. So it's not a violation of one's constitutional rights if somebody searches someone else's house, unless that person has an expectation of privacy in the premises. So that's the bottom line. Same thing with a vehicle. Remember, in a vehicle, and the leading case is Rakes. In a vehicle, a passenger has no legitimate expectation of privacy, absent certainly ownership or some other interest in the vehicle. So that if there's no ownership interest in the vehicle, the person's not operating the vehicle, or there's some other privacy interest in the vehicle, as a general point, the passenger has no expectation of privacy. And that's what Rakes did. Rakes sort of took the definitions, the CATS definition, remember, of what is a search, and consolidated it on the point of standing. So the question becomes, with respect to Fourth Amendment standing, is it a search as to this particular person? So that's the idea. So for example, if someone, the case is if someone is a passenger in a motor vehicle and the vehicle is searched and something is found, can they contest the search itself?
I see. Okay.
And then the answer is they cannot, because they have no legitimate expectation of privacy, reasonable expectation of privacy in the vehicle. But can they take it back one step? Linda, the stop is a seizure of everyone in the vehicle, not a bus, or not I suppose a train that was stopped, but it's a seizure of everyone in a passenger motor vehicle. Therefore, even a passenger can contest the reason for the stop. So if the police stop someone without reasonable suspicion, let's say, of a traffic offense, that's a seizure of the passenger as well. The passenger can raise that issue of the seizure of their person. They have standing to do that, but they don't have standing to raise the issue of the subsequent search, assuming, of the motor vehicle. You see what I mean?
Yeah, I got you. Thank you.
Yep. Anything else out there? Silence.
How many people are here?
I don't know.
How many people?
I can't see. I'm sure. Dan,
So I real quick, myself, Professor Johnson, and 9 students, I believe.
9 students. So 9 of you are silent out there. You must have something.
I know.
Go ahead. I had a professor in law school, and it was his first year as a professor. And he didn't call names, so nobody really talked. And that's the nature of law students, I think. Nobody really talked. And at the end of the semester, he didn't like our group very much. And I guess the kid was our student rep or something, bought him a T-shirt that said "Silence is golden." And he lightened up a little bit. Go ahead, Marvin.
That's okay. Can you touch base on sentencing procedures and the minimum sentencing guidelines and things like that?
Yeah, I won't deal with that too much. And you mean, what would you like to know about that specifically?
Well, just again, if we're responsible for any of the material, because in a lot of the cases they talk about the minimum guidelines and whether a judge followed them or not.
No, as I said, I think I sent you guys an email, and in the email I said I wouldn't test you on either fair trial, free press, that chapter, or also the sentencing stuff. So I won't test you. So don't worry about that for me.
Professor, I do have a question for you, kind of just going back and reviewing how we did on the midterm, right? Yeah. I want to get an understanding of what you're specifically looking for in our answers. Let's say, the 5th question on that midterm, dealing with someone who was trying to get in contact with their attorney and they weren't also properly Mirandized, and there were multiple issues in that fact pattern. When there are multiple issues, you expect us to, 1, do proper issue spotting and notate it. 3, are we looking for a very complex answer, almost explaining each of those issues, and how do you really look at that when grading? Like if we miss one, if we spot the issue and not explain 3 out of 5, how would grading work in that particular circumstance? I'm just trying to correct anything as I'm going right now.
If I give you a general idea now, that I can tell you a little bit about that. I know I wrote a longer answer when I sent out that email. But I can tell you a little bit about how I grade, if that'll help you. I mean, I can't be much more specific than this, but like in that, and I'll use your example as the example. That was a case. I don't have a. You have that in front of you? Would you mind just giving that a quick read? That question.
Yes. Here we go. Well, it's just the answer. It doesn't have. Actually, wait. I do have that somewhere. Here we go.
Sure.
So, question number 5. Yeah. The police have probable cause to arrest Wilfred for murder. Wilfred is arrested at the grocery store without an arrest warrant. At the police station, Officer Babbles says the following to Wilfred as they sit in a small conference room. Will, you don't need to say anything, but if you do, it can go against you. You can have a lawyer. If you can't afford one, we'll get you one. Okay? Willard responds, maybe I do need a lawyer. Officer Babel says, Will, did you kill Pip? Wilfred says, after about a 30-minute interval of silence, says, yep, he was a jerk. Unbeknownst to Wilfred, Wilfred's sister, Winifred, upon hearing of Wilfred's arrest, immediately hired an attorney, Charlie, to represent Wilfred. Attorney Charlie called the police department before Wilfred made his statement. The officer in charge of the station refused Charlie's request to put Charlie's call through Wilfred. Wilfred's new lawyer files a motion to suppress at the statement. A motion to suppress the statement. Discuss the potential arguments from all facts presented in the hypothetical. Will the motion succeed? Why or why not?
Yeah, that's, I can tell you the issues I wrote. And it would be the major issues, at least from that run through what I wrote, is the first thing is the arrest issue. And the arrest was for a felony. And the police, as you know, don't need an arrest warrant if they have probable cause to believe someone committed a felony. Even so far as, remember the case we looked at, a larceny type case, which is no danger. So exigency danger has nothing to do with that. If the police in a felony situation have probable cause to make an arrest, they can make that arrest without a warrant. So that's number one. The second issue, as you ran through my hypothetical that I pointed out to myself, is Miranda itself. And that the Miranda warnings don't have to be verbatim. So I mean, that's obviously what I wrote in that hypothetical. That was the question I was asking you. They don't have to be verbatim, but they have to convey the gist or the substance of the Miranda warnings. Remember that term they use, which sort of always sticks out, talismanic incantation. And that's the term that the court uses. And what they mean, obviously, by that is just basically a chant, a chant of the rights. It doesn't have to be perfect as long as the substance is conveyed to the suspect under questioning. So you've got the 2 points, obviously, interrogation and custody. And then the next point I picked up, and I'm sure it's in the answer, and I think these would be all basically, is maybe I need a lawyer. And that maybe I need a lawyer is an invocation of the right to counsel at that stage. Maybe I need a lawyer. It has to be an actual invocation for the request for counsel. So and I think that case is Davis, a Justice O'Connor opinion. And basically what she says is that it has to be because of the effect of an invocation of the right to counsel, that all questioning must cease. That requires a direct express invocation of the right to counsel. So maybe I need a lawyer wouldn't probably do it. That's the issue that comes up. And the suspect doesn't go back to that issue. So that's another issue. So the third of the, or the fourth, I guess, of the issues, major issues, is the interval. And it's the same thing on silence. And this is the period of silence when the question is asked. Is silence in and of itself an invocation of the right to silence? And the answer is no. So that, remember the case we looked at where they were asking him questions over a period of time, and it was a significant amount of time.
Right.
So I think it was a couple hours, and the suspect finally opened up his mouth, and that wasn't an invocation of the right to silence. And last but not least, was the issue about the lawyer is Moran versus Burbine. And that issue on the lawyer basically is under the federal system, the federal constitution. The only question is, was the waiver knowingly, intelligently, and voluntarily made? The fact that the lawyer was hired by a family member unbeknownst to the suspect and is running around outside the police department or in the police department or calls the police department really doesn't make any difference. The only issue goes as to whether or not goes to the actual voluntariness of the waiver. And of course, it has to be knowing, intelligent too. But that's the issue. Massachusetts law, I may have asked you one that I don't remember, is different. Massachusetts law, they have to tell them. So all those issues would be issues as I grade something like this issued, I'd expect you to address.
Okay, great. That was good to talk out. Thank you for the clarity.
Yeah, no problem. Glad to do it. We got, how many have we got out there? I can't tell.
You can scroll and see.
Yeah, no, I'm not touching the thing.
So let's see. We have 11 people, so we still have 9. We lost somebody in the process, but we have 9. I know Renee, if she can hear us, just joined us a second ago.
Okay. Hi, Renee. Any other questions out there?
So in that particular scenario, the person needed to know that the sister, whoever, retained counsel for the defendant.
I don't know if that would help, Jade, even. The court didn't really address that issue at the U.S. level, but I'm not even sure that would help. It really, the focus is, or was in that case, directly at the suspect and whether that waiver, knowing and intelligent, was voluntary. So if he doesn't know it's out there, if he knows the person's out there, the person's trying to get to them, that really hasn't been addressed. I mean, I could make an argument either way, but it hasn't gotten to the U.S. Supreme Court.
I see. Okay.
Probably not the answer you want.
Professor Johnson, in the Rhode Island case, wasn't there a similar fact where the relative hired an attorney and the police would not let that attorney?
Yeah, that's Moran versus Burbine. Yep, that's the case. That's the case on the point. And that was their focus, was whether or not it was a voluntary waiver.
So does that, so in this case, that's the same issue, right? Because, okay.
Yeah, I wrote it thinking about that case.
Okay.
Professor.
Yeah.
Please, can you clarify how the Edwards rule applied to the Sixth Amendment again, please?
The Edwards rule is a Fifth Amendment concept.
Okay.
Okay. And the Edwards rule basically is this, that once a person in the Miranda setting, in custody and under interrogation, and the Sixth Amendment has not yet attached. In those circumstances, Edwards basically says, if someone invokes their right to counsel, as opposed to silence, if someone invokes their right to counsel, then that person cannot be questioned by the police until counsel is present. So that's the Edwards rule classically. Remember, we looked at the case as well, where there's a break in the process. Remember the person, I think it was, if I have it, Schatzer, I think. But basically, they have the name right, but basically the person was a prisoner incarcerated for a period of time, and the police came to talk to him about a crime other than the one he was incarcerated for. He invoked his right to counsel at that point. And at that point, when he invokes his right to counsel, the police leave him. And then he goes back into the general population of the prison, and some time later, I think it was almost 3 years later, or 3 years later, in that case, the police come back, and a second set of police officers come back and talk to him again on that point. And that point involves basically, they ask him, give him Miranda warnings, waives Miranda warnings, makes incriminating statements. Is that the Edwards bar? Because the bar is, the presumption in Edwards is that any statement made after one invokes their right to counsel without counsel present is involuntary. And then basically from that point, that the court looked at that the gap, and they tried to come up with what would be a reasonable gap in terms of the individual as to when he can be questioned and when he can't, and they came up with 14 days. So the theory is somebody's in custody and under interrogation in a pre-charge Miranda setting. He's asked a question, he invokes his right to counsel. If he's released, and we looked at it in a prison setting, but if he's released, the period goes 14 days. If it's the next approach is after 14 days, the presumed bar is not there. the presumed bar is not there. So there's no presumed bar to further questioning.
Yeah, I just posted the link if anyone needs it. Maryland versus Schatzner, 2010 case.
Okay, great. Did that answer your question, Isaac?
Yes, you did. Thank you.
Okay. What else we got out there? Out there in cyber land.
Everyone knows criminal procedure like the back of their hand. They have no questions. They're going to ace this final. Is that what we're saying?
No, we're looking.
Relax.
I'm just trying to lighten
Oh,
everybody
I don't
up.
mean you, Dan.
Oh, no, yeah. I got you.
These guys are nervous. Kind of like looking at holding on to the notebooks too tight or something.
Can you speak more to DeRay, the case of DeRay?
What was that case again? Where is it in the book?
I'm looking at my notes, and I have something about DeRay on page 156.
Look.
I don't know if that's the case, but it was referenced there.
All right, yeah, so. Oh, DeRay.
DeRay, yeah.
Yeah, basically, that's a good question. DeRay is a case, not that, but it deals with the issue of individualized suspicion. And that the whole concept, and that's an earlier case on it. The best case to use that to help you think through it is Ybarra. Remember the guy in the bar?
Oh, yes.
So Ybarra basically is the case. The police execute a search warrant at the bar. And
the patron?
Yes, he's just a patron there. And the police search him for evidence. And the question is, it's a question of individualized suspicion. So the individualized suspicion they're talking about there is, unless there's probable cause, as you know, to search, the police cannot search for evidence, with exceptions. The main exception is the emergency doctrine, but they can't search for evidence. They can go in for another reason. But in Ybarra, they didn't have probable cause to search. The bartender supposedly was selling drugs, and there's no indication that Mr. Ybarra was involved in it at all, as he stood over by the pinball machine. And what the court said is you need individualized suspicion. DeRay is an earlier case, and the same concept is true in a motor vehicle. So if passengers, put 4 people hypothetically in a motor vehicle, in order to search the person for evidence, there has to be individualized probable cause to search that person. And that's really what DeRay is about.
Okay.
Professor, what page was that? 156?
What was it, Jay?
Yeah, there was a reference to it on page 156, but I don't think that's where the case was actually.
I don't think we read the full case.
Oh, okay.
Okay.
It's on 155, guys. So it's like the page right before. Yeah, that's where you see Ybarra and then States versus DeRay.
I see. Okay. 155.
It's on 156 in my book.
Yeah, I have 156 too.
They're both there. I think the concept gets introduced on 155, and then the second paragraph on 156 goes into it a bit more.
That's right.
Yeah. Yeah.
That's there.
Professor, I do have another question. I know you sent a document about a week and a half ago, general summary of identification procedures.
Yeah.
So 3 concepts on there. Third concept was the proposed subsequent in-court identifications. Can you talk a bit more about the due process exclusion and specifically the federal standard for it?
Sure. Basically, in the let me just grab my own notes. The identification procedure issues deal with excluded out of court identification for whatever reason, whether it's a suggestive, unnecessarily suggestive identification procedure, whether it's the lack of counsel in the right circumstances. And what happens, the process is what happens is that when can the police or the prosecutor propose an in-court identification? That's what they mean by that. So subsequent to an excluded out-of-court identification procedure. Let me give you a hypothetical and see if that'll get the point better. Okay, let's say that
Here, I gotta step away for 5 minutes, okay?
What?
I'm gonna step away from the computer for 5 minutes. I gotta take a phone call.
Okay, thanks, Dan. Let's say that basically the police conduct a lineup. And in the lineup, everyone's over 6 feet tall, except there's one individual with slightly gray hair, a gray beard, who's not near 6 feet tall. And that person is picked out as the assailant by the victim, let's say. That's a suggestive identification procedure. That's excluded on due process grounds outside the out-of-court identification procedure. But the prosecutor, let's say, wants to call the victim to the witness stand and put the victim on the witness stand and ask the question, which you see, which is certainly suggestive in and of itself. In a courtroom, the person sitting there in the courtroom, the defendant sitting in the little chair right beside his or her lawyer, his in this case, and the prosecutor says, do you recognize the person who, whatever the crime was, approached you and struck you or whatever in the courtroom? Yes, I do. Can you point that person out? That's the defendant. So that's the proposed in-court identification, the latter part of that little outline I put together.
Sorry, I didn't get that. When did you send that outline?
I sent, it's on email. I did it via email, Jade. So you'll see it out there, I hope. If not, just send me an email and I'll send you another one.
Okay.
So basically, and I think I posted on Dropbox too, didn't I? I'm not sure. I think it's on Dropbox, so you can get it there.
Okay.
So basically now the prosecutor wants to ask the witness that question. And the idea is it's sort of like, and conceptually, it's sort of like fruits in the sense that is it independent of the illegality? In other words, is the, if there's a suggestive identification or one made without counsel's, without the benefit of counsel in the appropriate situation, is this new proposed identification the product of that excluded out-of-court identification, the lineup, or is it from the incident itself? You see what I mean? And so that really is the question. And they list in Massachusetts, there are the Patello factors I listed on that thing. Opportunity to observe, degree of attention of the witness, all those different things that would indicate that the witness is testifying from the original event. So let's say the original event was a robbery and the witness only had a split second to observe the person. It'd be much more difficult for the government to sustain the ability to show that the out-of-court identification wasn't, the proposed in-court identification wasn't the product of the out-of-court identification. Do you see what I mean?
Yeah, that makes total sense. Thank you.
Yeah, and that's where it comes up, and then you'll see all those issues come up. And what happens is they look, at the length of time, the degree of attention, the conditions, all sorts of. In Master, the Patello, and federally, the Manson versus Braithwaite are the conditions where they're listed, and they talk about specifically those conditions and say, okay, is this identification really coming from the event itself, the robbery, or is it coming from the suggestive or counsel-less identification procedure?
Got it.
Okay.
I'm back.
Welcome back. You haven't missed much.
Mhm.
Anything else out there, guys? These run, in my experience, I don't know how long we've been at it, about a half an hour. These run, these little things run out of gas usually, and it's different on the little box here. But these run out of gas about, like I say, an hour and a half on average. So just kind of whatever you want clarified, let me know. And I can either clarify it or muddle it, but I'll try to clarify it.
This is a question about the final. Sorry, I don't know if you already discussed it. I was a few minutes late. Are we going to have Massachusetts law as well, or is it going to be like the midterm where we had that for extra credit?
What I'll do,
or are you talking about that?
Sorry,
Okay,
a little
sorry,
bit. Yeah, no problem. Don't worry about it. What I'll do is I'll send an email and give you the format of the exam, the final. So that won't be right now. That will probably be the email I send will be probably after the last class, which is a week from Monday for you guys. So I may do it this week. I may do it after the last class, but I'll try to get you something. So yeah, I'm not going to surprise you. There's enough surprises in law school and the times we're in. You really don't need any more surprises.
That's for sure. Did you talk about the federal rule of rules of criminal procedure, Rule 14? I have something dangling in my notes. I don't know why.
Well, like I said on the first class, I mean, we've referred to them at various times in the various cases, the federal rules of criminal procedure themselves. But by and large, except for the general process and where they're specifically mentioned in the course, there's really no need for you to worry too much about that. This is, the process and how things move through the process. Let me explain it to you a little better than that. How things move through the process is the first class, I think it was, that we looked at. The process, an arrest, the booking procedure, an arraignment, and what happens in the system throughout the course of that setting. And that, as far as I'm concerned, for our purposes here, other than the specific mentions of it in the cases and in your books, is all you really will need to know, how it moves through the system. The reason that is this is, they call it criminal procedure. It's a little bit of procedural work. Obviously, there's procedural due process issues and other things, and the rules themselves we refer to. But by and large, this is a constitutional law class as it applies to criminal cases. But like there are examples. Remember, we talked about the local magistrate federally. And that compared to Massachusetts. We talked about the, what else did we talk about? There was something else specifically on the rules. The federal, the definitions and issues with respect to knock and announce, which isn't quite as important as it was a few years ago, based on Hudson versus Michigan. But we talked about a number of those specific issues. But the rules in and of themselves don't sit down and read the rules for this exam or for this class, really.
Okay. I just had this Rules 14 discovery rules.
It's good to know that. Good to know that. It's not as important as you think, but those rules, the discovery rules, play into the Brady question. And the Brady question, of course, is what rises to the constitutional level. We talked about Rule 14, the discovery rule is the federal rule for discovery. And what you end up with in that setting is this idea, and I don't want to go too deeply into it unless you want me to, this idea of reciprocal discovery. So in other words, the government has to give its information to a defense attorney as part of the discovery rule. And in addition to that, the defense attorney has to give at least some information more limited than what's necessary for a prosecutor to give, obviously. And the idea is that, you know, the weight of the government is pressing against one individual, and that individual is entitled to know as much as he or she can about the prosecution against them. Whereas there are privileges and other things that restrict the reciprocal discovery, the going back in the other direction to the prosecutor. So the things we looked at in that sense, we looked at the idea of the notice of a defense. Remember the notice of an alibi defense on the issue of whether or not that was a violation of the Fifth Amendment to require a defendant under their rules to give the names and addresses of alibi witnesses. Is that a violation of the Fifth Amendment right? I don't have to be a witness against myself. Isn't that a violation of the Fifth Amendment? And the U.S. Supreme Court said, no, it's not in those circumstances because certain defenses, based on how the court reads it, certain defenses require, in terms of fairness, the truth-finding aspect of a crime, certain defenses have to be disclosed so that they can be reviewed by the prosecutor. The classic one is alibi, and that's Massachusetts rule too, but the classic one is insanity, defense of insanity, or Massachusetts calls not guilty by reason of mental illness. That's a classic case where that has to be disclosed and not sort of sprung on the prosecutor that particular individual is going to raise that defense when the person takes the witness stand. There may be so-called dueling experts in those kinds of cases. So there's a requirement that the defense attorney give up that information so that the issue can be tried fairly between the two parties without offending the Fifth Amendment. That's a case we looked at. We also, in that area, looked at Brady and the issue of discovery, and Brady's a little more complex. The bottom line is, if there's any exculpatory evidence, that is evidence that tends to help the defendant in their defense, that evidence, if it's known to the prosecutor or the prosecution team, has to be disclosed to the defense attorney if it's material.
Okay.
Can I ask a question?
Yeah, sure.
There seems to be two Jareds in the room. Is there a reason why? Two different Jareds, or?
I don't know.
So
yeah, sorry about that. I had to switch out of one of my devices because the phone the battery was dying.
perfect. I just want to make sure no malfeasance was afoot. I apologize. Sorry to interrupt, Professor Johnson.
I apologize for that. Yeah,
Thanks, Jim. No problem.
Device.
I can tell you what, if anybody's Zoom bombing this, they'll be here for about a minute and then be gone.
Really?
Professor Johnson,
Did
you're
we
still
go over-
planning the last day of class to have a full review session, is that right?
Yeah, that's what, yes. My intention is, and I recorded already the next to last class. Just like I do in criminal law, and I try to do it in both classes, which is why I moved reasonably quickly to finish the material. This particular aspect, that will give you an opportunity for me to run through. When I say run through, I mean run through some of the major points in the class. It's in the course, and it's by no means. I wouldn't go so far as to call it an outline. That might be an overstatement. But what I want to do is sort of overall get you thinking in terms of not just what we've been, the specific points which you do need to know, but the big picture in terms of how these things sort of fit together in the criminal justice system, and how like the trial rights, which we've talked about, and other things how the whole package comes together, I guess. And the only way to really do that is to broadly go through the whole thing, and then you can see where I'll hit some of the specifics too, as time permits, but give you the idea where these things fit.
Is there, this is Renee, I always have a hard time finding back the criminal procedure. Like you gave us the answers to the midterm, and did we go over that at all? I just want to go over a couple of the multiple choice questions.
We went over 5, I think, on the short answer question. Was that what we did?
Yeah.
But yeah, sure. You want to go over those? Shoot.
Well, if you already did, it's okay. I can just re-listen to.
No, we didn't. We just went through number 5 on the essays. So if you want to go through something else, that's no problem. Let me just grab maybe a copy of the exam here.
Okay. Yeah. Let me just. I have the exam up. I don't have the answers to it, but up for some reason.
Go ahead if you want on the exam.
I think, Renee, you were talking about the multiple choices.
Yeah. Was there something that I missed with that?
No,
we didn't
mention anything on that, Renee.
Okay. Yeah. Okay. So I think it was question. I'm trying to figure out which one I got wrong. Oh, you know what it was? Okay, it was the one with the cocaine and the marijuana. I'm sure someone who pops in here thinks it's interesting. No, that's question two. Question 2.
Go ahead, read it.
So the police just. Okay, sure. Police respond to a call that shots had been heard coming from a certain house. Upon arriving at the house, the police looked through a window and saw a man lying on the living room floor. The police opened the front door, which was not locked, and found that the man had recently been shot in the back and was unconscious. An ambulance was called. While the police were waiting for the ambulance, one of the officers walked through the house to see if anyone else was present, and no one else was found, but the officer did see clear plastic bags that he believed to be, based on his training and considerable experience, cocaine. The officer seized the bags, and later laboratory tests confirmed that it contained cocaine. After the ambulance arrived a few minutes later and took the man to the hospital, the police went through the house and opened drawers looking for the gun used in the shooting. No gun was found, but upon opening the drawer in the upstairs bedroom, a bag of marijuana, which is illegal to possess in the state, was found. So the police seized it. Is the last paragraph. So later investigation led to the charging of a woman who lived in the house with unlawful possession of cocaine and marijuana. The woman has filed a motion to suppress the use of both on the grounds that the entry and searches of the house were made without a warrant. And so the question was, how should the court decide the motion?
Yeah.
And the choices were whether to grant it to the cocaine or denied as the marijuana, denied as to the cocaine, but granted as to the marijuana, granted to both the cocaine and the marijuana, or denied to both.
Okay. And
I think the answer was C, granted to both.
No.
No. Well, I'm sorry. What was it?
I think it was B.
I got it wrong. It was D. Okay.
Yeah, I think it was B. Yes.
So why? So I guess my question is, I thought that the cocaine, I did A instead. I thought it should deny it to the marijuana, but I think I got tripped up with the cocaine piece, thinking that that was an illegal search. Right? How should she filed a motion granted to the cocaine? Yeah, that was an illegal search there. And I guess I don't understand how that would have been denied as well. If you could just go into that for the searches there.
How the cocaine was denied?
Exactly. Why would it be denied?
Okay. So the idea is this. You remember the remember they call it, depends on who you talk to, they call it the pure emergency doctrine. The pure emergency doctrine is basically involves the police going into a residence to render assistance. Not, the idea is not, at least the primary purpose, not to go in there to, although they may be in the back of their mind, it's really an objective question, to go in there and to help or assist someone who's in difficulty. That's the classic example. So in this particular case, they get to the house, they look through a window and see the person lying on the living room floor. And the police then have reason to enter the house to render aid to that person, right? The police enter the house, render aid to the person. They're waiting for the ambulance. They do not a full protective sweep, but the police can look in an area. You can see what how the hypothetical did. I didn't write this one, so it says, no one else was found, but the officer did see plastic bags that he believed to be, based on friendly experience, cocaine. So he does not a full protective sweep, but just a look around the house from areas, the immediate areas from where an attack could be launched. That's reasonable in these circumstances. Why is that reasonable in these circumstances? Because we've got a guy with a gunshot wound down. So they do that protective sweep, a little protective sweep, sort of. Then afterwards, the officer, after the ambulance arrives, they take the guy away. The police go through the whole house. Arguably, I suppose, arguably, they could go through the house because there's reasonable suspicion for a full protective sweep because somebody shot the guy. And the concern is that person, he or she, might still be in the house. But what this officer did is he opened the drawers. You see what I mean? And when he opens the drawers, what's he looking for? He's not looking for a shooter. When he opens the drawers, he's not looking for the danger. He's not looking for that so-called protective to end a potential threat. What he's looking for is something else, evidence. You're looking for evidence? Is there exigency? Can't look in every drawer for a gun. No. What should the officer have done? The officer should have gotten a search warrant to go through the house to search for the gun. Then it would have been admitted. But in this case, what's their justification for being in? The justification for them being in is the emergency situation they're in. Certainly, I mean, the argument is it's justified for them to look around based on the fact that the guy got shot and via a gunshot. So somebody did it. Is the person right around going to attack the police? The next level of the protective sweep is probably even reasonable suspicion for them to go up into the rooms after the ambulance arrives. Couldn't have been too long. But they can't start opening drawers because nobody's hiding in a drawer. And that's the idea. Closets, yeah. Drawers, no. And that's where they found what was it, the gun? Oh, pardon me, found the marijuana. So the cocaine's in. Why? Plain view, prior valid intrusion, police, and a place they have a right to be a little protective sweep, the initial protective sweep. And secondly, the full protective sweep, maybe they have a right to be there, maybe they don't. But with respect to the opening of the drawers, they can't do that because they're now looking for evidence. They're not looking to protect. And objectively, they're not trying to protect the police. So that's the reason behind that.
Gotcha. So the answer is B, denied to the cocaine, but granted to the marijuana because he was looking for, looking through the closet for a suspect is reasonable, but through the drawers when no one can fit, that's exactly. Okay, gotcha. Okay, I must have slipped it. Okay.
They thankfully they didn't do that to you because, I mean, it gets closer. It gets closer with the closets and how long afterwards is it, is it still reasonable to believe an assailant might still be there? All those things come into play, but it's not close with the drawer. So that was I think the way they dealt with it.
Thank you.
Sure. How we doing, guys? Anything else? Andover?
So there was
Not
a-
in the Andover anymore.
really.
Well, yeah, we're not, what was it? We're not in Kansas anymore, right?
So there was a recent Supreme Court case which ruled that the all criminal cases have to be unanimous.
Yes.
Which it appeared that Louisiana was the only state that allowed someone to be convicted without a unanimous.
Right.
Is that okay? I just wanted to make sure that that was just that Louisiana was the only holdout at that point, right?
I think Louisiana, since that case was decided, and I read the opinion a bit, but I can't say I fully read it. But I think Louisiana, since that Ramos case was tried, got rid of the non-unanimous jury possibility. So that got rid of it. I think the only one left then was Oregon, which still had the possibility of a non-unanimous jury in a criminal case, and now that's unconstitutional. As I read it, I read a little bit of the commentaries on it, but I haven't, when I read them, I sort of sit there and really read them. I haven't done that yet. I haven't had time to do that yet. But the bottom line is, I think it was 6-3. 6-3 of the justices said it's a violation for a non-unanimous jury in a criminal case. Even with 12. Remember, we looked at the case that said 5 out of 6 wasn't enough, but that takes it a step further.
Okay. And that's for all criminal.
Well, it looks it. Yep, like I said.
Even petty criminal.
No, see that I mean, it's funny you asked that.
I think it's in serious cases. I think it said.
They said serious. And then
Okay.
what's his name dropped a footnote. Gorsuch, who wrote the opinion,
Mm-hmm.
there's a footnote he dropped and basically said in serious cases. Doesn't really define it, but later in the opinion there's a little footnote. I think it was footnote 7 or something that said we made the reference to petty. It's always been the case in non-petty crimes. So I think that's where they're sort of drawing the line, non-petty crimes, greater than 6 months, historically.
Okay.
Professor, just on the same theme of reviewing the midterm, just because, we're getting closer and, any mistakes that we can correct now, I think would be super important just for, to enhance the learning experience. So looking at part 2 of the short answer questions, could we talk a little bit more about question 3? Because I know you mentioned some folks didn't spot the issue right away. Actually, no, number 1, I'm sorry. In number 1, we didn't spot the issue right away. And I am one of those that did not do that. I went down the fruit of the poisonous tree rabbit hole and didn't realize it was a state actor thing. So more than happy to talk that out as well.
Yeah, nobody's perfect.
That's true. That's true.
Yeah, well, a number of people didn't catch that issue. Some did, and a number of you didn't. If you want to read through, you have it in front of you, just give it a quick read for those of, I have it, but for those of us who don't, if you don't mind. You want me to read it? I'll read it.
I got it. So here we go, part 2. So Roger is a private security guard at a mall. He has seen one too many police dramas on television. Roger approaches Officer Ollie of the the police department. Roger says, "Hey, Ollie, I hear Penny Posh might be dealing heroin from her mansion at 10 Tumbleweed Terrace." Officer Ollie says, "Well, that's not enough for a search warrant, but keep your eyes and ears open and always do what's right." Roger immediately goes to 10 Tumbleweed Terrace, breaks down the door, enters the living room, and sees a large bag of heroin. Roger picks it up, leaves, and goes directly to Officer Ollie, still walking on the beat on the street, and says, "Here, Ollie, I told you she was dealing," and he hands Ollie the bag. Penny is charged with the statutory crime of possession with intent to distribute heroin. Penny's attorney files a motion to suppress the bag of heroin on her behalf. Will it succeed? Why or why not?
Yeah, the issue, everything breaks on the state action issue. Because if, what was the lad's name? Roger. If Roger is acting on behalf of the state, then it's clear that he violated the Fourth Amendment, breaking down the door without a search warrant, going through the house, and finding the large bag of heroin in the living room. So that's clear. So the question goes back to that. Is he a state actor? Is he acting on behalf of the state? Because the exclusionary rule, the amendments themselves, only apply to state action. If you're looking at if you want to see language about that, remember what the 14th Amendment itself says: no state shall, and so it applies to state actors. So the question starts with: is Roger the security guard a state actor? And all that officer always says to him, it's a totality of the circumstances. The case we looked at, I think, was, or one of the cases, I know we looked at a number of them, was Coolidge. Remember, in Coolidge, there was a homicide in New Hampshire, and the suspect's wife was asked if she could search for his clothing in the house. Remember that? And so the search was for the clothing in the house, and she said yes, and goes and gets it. And the question became, is she acting as an agent of the state? Because then that search is subject to the Fourth Amendment. And the court in that case said no, she wasn't. Why? Because she testified that she thought he was innocent and she was trying to help him out and prove his innocence. In our little hypothetical here, Roger, what Ollie says to Roger is he telling him to do something, and I left it sort of ambiguous to see what would be said, but I said, well, that's not enough for a search warrant, but keep your ears open and always do the right thing. And I think most people who looked at it concluded he wasn't acting as a state actor. I suppose a defendant could make an argument, well, that's not enough for a search warrant, but keep your ears open and always do the right thing is in some way a direction to him to go resolve the problem and get the right thing done. But that's kind of a stretch, if you ask me. So he's probably not acting as a state actor. Since he's not acting as a state actor, the evidence won't be suppressed. That's the major, the key to that case. The rest of it deals with, is it the fruit of an unlawful search? Yes, but it's the fruit of an unlawful search that took place via a private citizen. You see what I mean?
Got it. So instead of looking at the state actor piece, I jumped to the evidence.
Yeah.
So, okay, that makes sense.
I mean, it's blatantly wrong what the guy did. It's just the issue: is he acting on behalf of the state? And if he's not, the evidence doesn't have to be excluded. If he is, boy, does the evidence have to be excluded.
Right. Okay, this is good. It just helps to like slow down as we're analyzing these.
Yeah, no, I'm glad to do it. Anything else out there, guys? Go ahead, anybody?
Can you talk about the Strickland test?
Yes. I mean, I won't get the notebook, which I could do. It's right in front of me, my own notebook. But I'll go through it with you briefly. That's a tough concept. Ineffective assistance of counsel is what you're talking about, obviously. And it's a tough concept because there's so much to it. But the basic Strickland test is this: someone raises. Let me see if I go through it with you. Someone raises a claim of ineffective assistance of counsel. And with respect to Strickland, there are two prongs to that test. The first prong is whether or not counsel was ineffective. And what they mean by that is at a stage where someone has a right to have an attorney, a critical stage where someone has a right to have an attorney, did this attorney's performance fall so far below reasonable representation of the client, the defendant, that it deprived him of the right to counsel.
Can you give an example of what that would look like?
Oh, the cases, some of the cases in the book talk about instances.
Mm-hmm.
One case that they talk about is at a sentencing phase, for example. In a sentencing phase, the attorney didn't even get a social history about his client, so never in fact got a social history. You know what I mean by a social history, mother, father, a background.
Psychosocial history?
Yeah, so the argument from a defense lawyer would be to the judge, this defendant, his mother and father are these people. He's had these things in his background. Maybe he's had a difficult background for some reason, mitigating things that can be argued either to a judge or jury, whoever's doing the sentencing, that would lessen his or her exposure to a larger sentence based on the circumstances of their life. So this attorney at that stage didn't even get a social history in terms of trying to mitigate the severity of the sentence. So that's one classic example of what would be a ineffective assistance. The second form is that you need prejudice. Prejudice. Let me just get that 1 second. What page are you on in the book? I just want to get the language right for you.
I don't have the page number. It's under the that was chapter one.
I got it. No problem.
695.
695.
Strickland is page 910.
What page? 910.
Page 910.
Yeah.
Nice, Martin.
I just want to get the language right because they say prejudice. The first part of the test, to use the exact language from Strickland itself, that is ineffective representation in light of all the circumstances with the identified acts or omissions outside the range of professionally competent advice. And they point out something I should have mentioned. There's a strong presumption in these cases that counsel is exercising reasonable professional judgment. The term prejudice is the second prong. So you've got the first prong, you got that ineffectiveness. And the second prong is the defendant must show that he or she was prejudiced by counsel's error.
I see.
And they use the materiality test, basically the same materiality test they use in Brady in the context of exculpatory evidence for materiality. That is a reasonable probability that but for counsel's unprofessional errors here, the result of the proceedings would have been different. So that's the Strickland test. Now these cases in your book, this is when it really gets in a procedure, criminal procedure. These cases in your book, and I directed you, I think, or suggested to you that you look at Lefebvre on the idea of the habeas corpus petition. And really what it amounts to is, and I'll just give you a short version of this, that generally speaking, So not always true, because I've seen cases of my own where they were appealed and one of the arguments was ineffective assistance of counsel. But by and large, this issue, the commentators say, and I think it's probably true, is not raised on direct appeal. So the trial takes place, the sentencing takes place, and there's a direct appeal, as you know, to usually in the state courts and the federal court as well, a mid-level appellate court. And then there's an appeal, a direct appeal to usually, sometimes as a matter of right, sometimes not, to the state's highest court in the states. So what happens is this. That's usually or often not litigated. Ineffective assistance of counsel might be, let's say that the argument may be that there was error by the judge in trial instructions. There was an error by the judge in allowing evidence in and denying a motion to suppress. Those kinds of things will go up on direct appeal. What happens as a general principle is that this is litigated in the federal courts via habeas corpus. That is a writ of habeas corpus, and the argument being that the constitutional rights of the convicted defendant were violated in the state's proceedings. So they're litigated there. And the little quirk in the book, it's not a quirk in the book, it's a quirk in the law. What happens is that if that issue is litigated in the state courts, that is litigated by ineffective assistance of counsel claim, either by a state, I know, bear with me, I know it's a pain in the neck, a state habeas corpus proceeding, or in the direct appeal in the state, the standard of review in the federal courts is different. That's it in a nutshell. But your question on Strickland, those are the basic answers, and that's by far the leading case on the topic. That's probably too much information.
Yeah, that was too much.
That can happen. You start a law professor talking, that's what happens.
I thought you nailed that. I thought it was a good explanation, actually.
So are you going to take my exam for me, Dan,
At this time, you're probably better off position than I am. I haven't studied Crim specifically in a while, but this is a very fascinating topic, to be honest with you. So interesting review today for me listening to.
Anybody else out there? Still see some of you are here.
Looks like they're all good, Harry.
You guys all good? Don't forget email, because you can email me and I'll try to answer your specific questions. And not too many have, but some have. But email me if you have a question, and then I'll kind of blast out the email to everybody if it's, I think, something anybody would like to know. I know you guys too are coming up to the end of your classes. Of course, we have one extra the Monday, so I'll talk to the little box before then. But if you, and I know things are getting busy, but if you have questions, you're focusing on this in studying, just send me an email. I'll probably send an email out to you telling you I'll stop taking questions at some point close to the exam. But by and large, I'll be around. I mean, what the heck? Where am I going these days?
Very true, I guess, yes.
Last shot. Anything else? How long have we been at this?
1 hour, 10 minutes, exactly.
1 hour, 10 minutes. This is, like I said, this is just about how these run. And it seems that even with the assistance of this box, this is how this one's running.
I agree. About hour 15 minutes usually when these sort of meet their natural flow.
Yeah. Anything else, guys? Okay.
No.
No, thank you.
This was
Thank you
helpful.
so much.
That helped? Great.
Yes, thank you.
My pleasure. I'm glad to do it. I hope go out and enjoy the weather. I wouldn't say don't think about criminal procedure for the next couple hours, but I'm not going.
I'll be reading outside.
That's a good compromise. Take care.
All right. Thanks, everyone.
Take care,
Bye.
See you. Bye-bye.
Bye.
Nice to see you.
Same here.
Bye-bye.
Bye-bye.
Thank you, Dan.
No problem. Thank you guys for showing up. So
Dan, thanks very much.
I'm gonna hit, no problem. I'm gonna hit, let's see, recording. Do you want to start?